Thank you very much, Becky Freeman, for that wonderful talk. Thank you too to James Farrell for chairing the session, and thank you to the next speaker, Coral Gartner, to come along and talk about the tobacco endgame. Tonight I'm going to give the bridging talk, as it were, between a couple of the public health discussions and really look at some of the legal issues associated with tobacco control and the plain packaging of tobacco products. Just to begin with, I'd just like to kind of highlight that we released an open access version of the QT Law Review, looking at plain packaging of tobacco products, looking at the Australian experience, but also looking at a number of countries like Canada and New Zealand and the United Kingdom and Ireland who had followed the example of Australia. Dr. Freeman has a chapter on her home country of Canada. But that is a really useful resource, looking at some of the history and debate in relation to plain packaging of tobacco products. And Dr. Freeman has also kind of written with Simon Chapman a history of the struggle for the introduction of plain packaging of tobacco products in Australia. In my presentation today, I really want to kind of focus in on several countries and how they have implemented plain packaging of tobacco products in the Asia Pacific. So I'd like to explain to you Australia's successful defence thus far of plain packaging of tobacco products in an array of different fora, briefly mention what has been happening in New Zealand, and then talk about the exciting news of Thailand introducing plain packaging of tobacco products this week. And Singapore has also kind of announced that it's going to introduce plain packaging in the coming year. So really I'm going to focus upon some of the pioneers of plain packaging of tobacco products in the Asia Pacific. And I also want to kind of suggest that perhaps it's a more complicated story than merely one of Australia providing leadership and other countries around the world merely adopting the Australian model. I think that a number of these countries have been very important allies for Australia, particularly in the World Trade Organisation dispute, when third parties kind of played a very important role in voicing support for Australia against various different challenges. But also I think there's been an interesting kind of process of translation and adaptation that has gone on as Australia's regime has been taken up and deployed in other countries. And I think there'll be some interesting questions comparatively in terms of how plain packaging of tobacco products has worked. At least from my perspective, it's been a kind of a very dramatic shift in my lifetime in terms of how Australia has dealt with tobacco control. Growing up in Australia in the 1970s, tobacco advertising was ubiquitous. I can remember, to my shame, nagging my father to take me to McDonald's to buy an Australian cricket one-day poster which was funded by Benson Hedges. There was massive tobacco sponsorship, there was very significant advertising, and Australia was really kind of considered to be Marlboro country and kind of was dominated by smoking in a very significant way. And then, in a cumulative fashion, Australia has passed over the last few decades a number of tobacco control measures which build upon one another to try to provide a comprehensive suite of tobacco control measures to tackle the tobacco epidemic. As Dr. Freeman kind of noted, it's really a complementary set of tobacco control strategies that have been used together, reaching their kind of apogee in the introduction of plain packaging of tobacco products, which builds upon graphic health warnings but strips away some of the remaining advertising that was still present in relation to graphic health warnings. In some ways, my interest in the topic was sparked by Dr. Freeman and Professor Simon Chapman ringing me up and asking me to help them with a paper that they are writing at the time on the case for the plain packaging of tobacco products. And we had old evidence from internal documents within the tobacco industry that they were planning various challenges to the introduction of plain packaging of tobacco products under intellectual property law, under investment law, under trade law. as a researcher who had done a lot of work on access to essential medicines, I kind of worked from first principles and thought that, well, if we can have public health exceptions and defences in relation to intellectual property to enable access to essential medicines, surely we should have similar flexibilities in place to deal with the tobacco epidemic. So in our kind of piece that we wrote, I had a little bit about the legal defensibility of plain packaging of tobacco products. We sent that article off to Nicola Roxon's office, and surprisingly enough, we got a bit of interest back, and Nicola Roxon seemed very interested to know whether or not she would be the first one to introduce plain packaging of tobacco products in the world, and what sort of impact it might have. So in some ways we're very kind of fortunate at that particular time that we had written it at that particular moment when we had a very receptive legislator in a position of power as Minister for Health, and then as Attorney General she also kind of masterminded the defence of plain packaging of tobacco products. The World Health Organisation has taken up the call for other countries to adopt tobacco control measures like plain packaging of tobacco products. And we've had an array of early adopters thus far. Following Australia, we've had a range of European countries like France, the United Kingdom, Norway, Ireland, Hungary, New Zealand has implemented plain packaging of tobacco products. And then we've kind of had an interesting mix of next wave of countries, including Turkey, Saudi Arabia, Singapore, Canada, Uruguay, Slovenia, Belgium, Israel and Thailand follow suit in relation to putting forward plain packaging measures. There's perhaps a score of other countries that are kind of considering policy recommendations in relation to plain packaging of tobacco products. The tobacco industry, of course, has been trying to attack Australia's regime to scare off these other countries from following Australia's lead, from experimenting and innovating in relation to tobacco packaging and tobacco labelling. So we've seen a number of different challenges that have been ranged against Australia, but there's also been some domestic challenges in the United Kingdom and France as well. In spite of their arrogant hubris in terms of their internal documents, the tobacco industry has been on a losing streak across a range of different arena, in various different courts. They have lost challenges to plain packaging of tobacco products. And really, I just want to focus a little bit upon Australia's successful defence of plain packaging of tobacco products and how that has encouraged some other countries to take up such measures in other jurisdictions. In Australia's case, we're very fortunate that Nicola Roxon was a very accomplished lawyer who had been an associate to Mary Gaudron, the first woman as a judge on the High Court of Australia, and was very well versed, amongst other things, in relation to constitutional law. So she had no fear of threats by the tobacco industry that they would challenge any legislative measures that she was going to introduce. But also because she's a very methodical person, she commissioned lots of public health research to ensure that the measures that they were putting into place were evidence-based and had a robust foundation of public health research behind them. But she also sought to ensure that the regime was designed in such a way to weather any potential legal challenges. So, for instance, they kind of ensured that the tobacco industry wouldn't lose their intellectual property as a result of the measures. In particular, trademarks would remain valid, even though they would be subject to such regulations. The challenges came thick and fast once the Labor government passed the laws through federal parliament. In the High Court of Australia, the tobacco industry launched a constitutional challenge against plain packaging of tobacco products. They also coupled that with a very intensive media campaign suggesting that the Nicola Roxon and the Labor government wanted to institute a nanny state in Australia. Of course, the phrase nanny state, if you look back at its origins, came from a British minister who had a habit of heavy smoking and died of a heart attack. But nonetheless, that rhetoric has been picked up and deployed by the tobacco industry in various different parts of the world. David Pope from the Canberra Times had this wonderful cartoon as Nicola Roxon as a Mary Poppins-style figure busting big tobacco in the High Court case. I went along in person and witnessed the oral proceedings in relation to this matter. There was a huge amount of legal resources that were deployed in this dispute. The tobacco industry had 4 different companies involved in the action. The federal government was busy defending the regime. A number of state and territory governments also kind of intervened. The Cancer Council tried to intervene in the matter, but Chief Justice French wouldn't let them be fully involved in the case. Really, the matter was very much focused upon the singular question of whether or not plain packaging of tobacco products constituted an acquisition of property. And the tobacco industry kind of argued that intellectual property was a form of property and the Commonwealth government had acquired it. Led by Stephen Gageler, the Solicitor General, the Commonwealth said plain packaging was not an acquisition of property. The Commonwealth had long regulated labelling and information in various different ways, and really the regime preserved the intellectual property rights of the tobacco industry. In the end, the High Court of Australia ruled very decisively 6-1 in favour of the Commonwealth. There were 4 main justifications for the decision that plain packaging of tobacco products did not constitute acquisition of property. There was an emphasis upon the history of regulating labelling in Australia. So the now Chief Justice Kiefel from Queensland noted in her judgment that there had been a long history of the government stipulating labelling requirements in relation to food and drugs and baby formula. A couple of the junior lawyers got to argue about plain packaging of margarine in Britain back in the 19th century. But essentially there had been a long history of governments using behavioural nudges or engaging in behavioural economics, encouraging citizens to make healthy choices through labelling. The second point that was made, particularly by Chief Justice French, was that intellectual property does not serve to provide absolute rights to private property holders. Intellectual property is designed to serve larger public interests, including the protection of public health. And he kind of emphasised that just because you have intellectual property rights does not mean that you can ignore government regulations altogether. You're still bound by government regulations. So there was a very strong statement in the decision about intellectual property serving larger public purposes. Thirdly, there was also a consideration of some of the precedents dealing with acquisition of property. There was also a kind of a discussion that there had been past precedents which had noted that, governments can create intellectual property rights, but they can also regulate them and create exceptions in various different ways. And in this particular case, the Commonwealth government had not acquired the intellectual property. The tobacco companies still held the intellectual property in relation to their trademarks and design and copyright and even patents. Finally, Big Tobacco had kind of argued that it would be a slippery slope. If you introduce these regulations, there would be plain packaging in relation to food and soda and alcohol and a whole host of other things. And the judges on the High Court of Australia said, we don't have to decide whether or not the decision has wider ramifications for other areas. That's not necessary. So a very decisive win, 1 dissent by Justice Hayden, but even Justice Hayden noted that the tobacco industry had a record of lies and deception in his dissenting judgment. The tobacco industry then had this collateral attack on that decision through an investment agreement between Australia and Hong Kong. That investment agreement had a provision for investor-state dispute settlement, which meant that a foreign investor could bring an action in an investment tribunal against the government if it felt that government regulations adversely impacted their foreign investments. Philip Morris shifted their assets from Australia to Hong Kong to try to take advantage of this regime. Chief Justice French was quite aghast at this tactic. He gave a very stiffly worded speech to his fellow judges, suggesting that investor-state dispute settlement shouldn't be used to upset and disrupt domestic court decisions. In any case, this matter proceeded in terms of the investment tribunal, and in the end, the Permanent Court of Arbitration published a decision on jurisdiction and admissibility, and the essential essence of their ruling was that Philip Morris had engaged in an abuse of rights. They fully knew that plain packaging was going to be introduced in Australia before they made the decision to move their assets to Hong Kong. So the tribunal was of the view that they couldn't take advantage of the investor-state dispute settlement regime as a result of that decision. And the tribunal was precluded from exercising jurisdiction over this dispute. Philip Morris were also unsuccessful in a parallel dispute against Uruguay over graphic health warnings, but in that particular case it went to a question of substance as well as questions of procedure. Bill Gates and Mike Bloomberg set up a fighting fund to help defend Uruguay against that very expensive action brought by Philip Morris under an investment agreement between Switzerland and Uruguay. Most recently, Australia has defended plain packaging of tobacco products in the World Trade Organisation. Dr. Craig Emerson, as Trade Minister, emphasised that plain packaging of tobacco products was not anti-trade, it was anti-cancer. And he was fully confident, as the Trade Minister for Australia, that Australia would be able to defend its regime. And Australia has done that in the first instance of the dispute. So we had an array of challenges, including Ukraine, the Dominican Republic, Honduras, Cuba and Indonesia. Strangely, Ukraine dropped out of the action midway through the oral proceedings. They had very similar arguments. Essentially, they argued that Australia had violated the TRIPS agreement dealing with intellectual property, the Technical Barriers to Trade agreement, and also the GATT agreement. But Australia said it was implementing the World Health Organisation Framework Convention on Tobacco Control, and its regime was consistent with the TRIPS agreement, the Technical Barriers to Trade agreement, and also the GATT agreement. The first instance decision is an epic decision that is over 1,000 pages. It covers the significance and importance of the World Health Organisation Framework Convention on Tobacco Control. There is extensive debate over the empirical evidence on the efficacy of plain packaging of tobacco products, both pre-implementation and post-implementation, and critically Australia was able to demonstrate, based upon the wealth of public health evidence, that plain packaging of tobacco products was going to be effective in a range of different ways, and the post-implementation evidence supported that. So that was very helpful to demonstrate that the measures were necessary under the TRIPS agreement to take, that it was not an arbitrary or unjustifiable measure in relation to technical barriers to trade, and it was able to show that it was not otherwise a disruption in relation to the GATT agreement. The matter has been appealed by a couple of countries, the Dominican Republic and Honduras, so we have two countries left. They are appealing a limited range of legal issues associated with the TRIPS agreement and the Technical Barriers to Trade agreement, but they are trying to, very strangely upon appeal, challenge the fact-finding by the first instance panel upon the effects of plain packaging of tobacco products. So very strangely, it's become quite a meta-dispute about what you can and cannot do in relation to dispute settlement. Australia should win that appeal. The only strange thing at the moment is that the Trump administration is not allowing appointments to the appellate body. So appeals are being somewhat delayed in terms of the system. So that's Australia's story in terms of its successful defence. I guess the only other thing that I would add is that the Trans-Pacific Partnership, a regional agreement, has come into force this year with 6 or more countries agreeing to that regime. That has a special measure to stop investor actions by Big Tobacco against member states of the Trans-Pacific Partnership. But there's no special protection for state versus state matters. So there's a partial defence there, just dealing with investor-state dispute settlement. Just kind of moving on quickly, New Zealand in some ways was inspired by the Australian example, but they also were very much kind of inspired by some local concerns as well. So the Maori Party was a key driver of some of the law reform in New Zealand because of the concern about the high rates of tobacco use and consumption amongst the Maori communities. New Zealand was very helpful, supporting Australia and the World Trade Organisation, making supporting arguments about the significance of the case and how it was important to deal with death and disease in New Zealand as well as Australia. And New Zealand made detailed arguments in support of Australia within the World Trade Organisation. John Key unfortunately dithered a little bit, the leader of the National Party at the time, in terms of what he would do in relation to plain packaging of tobacco products. He was a little bit nervous and concerned about a possible investor action being brought against New Zealand, but he seemed to kind of get more confidence as there became a stronger evidence base about the efficacy of plain packaging of tobacco products. Interesting debates within the New Zealand Parliament from the various different parties. As I said, Dame Turia was very kind of keen as a coalition partner with the National Party in pushing through that regime. The Labor Party had very eloquent speeches by Clare Curran about being a smoker herself and how she was enticed into smoking at a young age. The Greens also kind of contributed to that debate. There were some minor parties that voted against the New Zealand regime. Some really interesting adaptations in terms of plain packaging in New Zealand, involving, amongst other things, the inclusion of Maori languages in terms of some of the messaging that has been used, in terms of the plain packaging that has been introduced. And the new Prime Minister of New Zealand, Jacinda Ardern, is very keen on providing further leadership in relation to tobacco control. She's been very cynical about the efforts of Big Tobacco to push vaping. Just shuffling along to some positive examples in Southeast Asia. Thailand, as I said before, has progressed rather rapidly in terms of its labelling systems. So Thailand initially had a state-based monopoly back in the late 1980s, early 1990s in relation to tobacco production. Over a number of years, they've kind of ramped up their labelling measures in relation to tobacco control. So up until recently, they've had large graphic health warnings, and they've kind of added to that very recently with the introduction of plain packaging of tobacco products this week. Notable in the World Trade Organisation, Thailand was a good ally and supporter of Australia and kind of noted that, a number of countries were waiting upon the decision of the World Trade Organisation before they made their decisions and choices in relation to plain packaging of tobacco products. From their perspective, they thought it was really important in terms of the larger issues surrounding the importance of public health and the ability to take action in relation to public health under an intellectual property regime. They also really said it was important to look at the objectives and principles of the TRIPS agreement, but also some of the larger declarations about access to essential medicines, which emphasised that member states should take advantage of intellectual property flexibilities to deal with public health issues. Thailand has gone ahead and introduced plain packaging of tobacco products, which is a really significant and important move. And as you can see, that there's been some interesting experimentations in terms of the sorts of labelling and the sorts of images that they've been using and deploying. There's been great joy amongst the public health community about the introduction of such measures, and the World Health Organisation has congratulated Thailand on being the first in Asia to introduce plain packaging of tobacco products. And amongst other things, there's been a little bit of discussion about how the regime will work. In our collection, there was a lot of discussion about how the compliance measures have been tested in Australia, and I think that's going to be a very big issue as well in Thailand. The World Health Organisation also kind of emphasised that it was not only important in terms of public health, but it was also important in terms of the larger sustainable development goals, particularly the goal focused upon good health and well-being, which picks up the need to tackle the global tobacco epidemic. I just want to kind of wrap up by also flagging that Singapore is also following suit. Singapore, in addition to relying upon some of the evidence presented to some of the Australian inquiries, has engaged in some of its own research in relation to how plain packaging of tobacco products might operate in Singapore. And in addition, they kind of provide support for Australia and the World Trade Organisation. But really interesting evidence coming out of the research done and that was commissioned in Singapore. And Singapore will be the next country to introduce plain packaging of tobacco products. Cancer Council, amongst others, have complimented Singapore upon their new regime. So just to wrap up, Australia has provided leadership in relation to the adoption of plain packaging of tobacco products. There have been a number of other countries in the region that have followed suit. But as Dr. Freeman has noted, there have been a number of recalcitrant countries. Indonesia particularly has been a Disneyland for big tobacco and has often been ranged in opposition against Australia and the World Trade Organisation over tobacco control. China has also been very kind of concerning with the amount of state-based tobacco production and has often sent very mixed messages. Japan, with its close connections to Japan Tobacco International, has often slided into arguments reminiscent of those of big tobacco. India, though, seems to be shifting towards adoption of stronger tobacco control measures. It's adopted graphic health warnings and today has banned vaping. There's lots of ongoing debate in Pakistan about whether or not it should push beyond graphic health warnings to plain packaging of tobacco products. Now I'd like to shift on to our next speaker, who will consider tobacco endgames and working out what combination of measures might be the best way to end smoking altogether in the Asia Pacific.